Welcome to Case by Case. This is a podcast brought to you by Calum. Today, Ed Floyd and myself, Luke Sadkovich. How are you guys?
I'm good. I'm joined by the dream team.
Doing very well, and happy to be on Case by Case with you and Calum.
And we've got a great topic today. I'm really looking forward to this one. We're delving into the world of Rico, a particular US action, a private civil Rico suit. It's something that we know well, Ed, isn't it?
That it is. Rico, for any of those out there who are not familiar with it, is the Racketeer Influenced and Corrupt Organizations Act in the U.S. And as you might infer from that name, it deals with criminal activities and racketeering, but also holds out the promise of possible private causes of action against wrongdoers.
Yeah, absolutely. And it's not, as the name would suggest, just limited to the type of mafia action you may see in the Godfather movies. But as we will see in this particular case, it can extend to lots of different wrongdoing.
Yeah, that's absolutely correct, Luke. And as you noted earlier, you and I collectively have a good deal of experience with Rico and Rico actions. But the classic scenario for a Rico case is what some courts have termed the pizza shop scenario, where a criminal organization effectively takes over a restaurant, so to speak, and utilizes it for money laundering or for other illegal activities, and thereby injects a criminal element into an otherwise proper business.
And have you come across Rico, Calum? Is this something that is completely new to you, or have you seen these types of cases before?
I'm familiar with the term, but I've not seen or been involved in a Rico case. And I didn't know until reading this judgment whether or not Rico is something that you could avail yourself of as somebody outside of the US. And actually, this is a really interesting case for our non-US listeners. It goes to exactly that point. If you are not a US resident, or you're not a US domiciled company, do you have the standing to bring a claim on under this or to bring a Rico claim?
Yeah, you're right, and it's a fascinating dimension to Rico, and I think it's fair to say that the law is continuing to develop around, some of the limits, or how far Rico can reach, and you have this kind of concept of a presumption against extraterritoriality in the US. And Rico is one of those areas that I think is really interesting to examine, because you can see the limits of that, and where the kind of national limit on these things is. But as we see in this case, if you are a foreign party, a party outside the US, you can still avail yourself of Rico in certain instances. And of course, we'll get into in some detail the concept of domestic injury for the purposes of a Rico action. But just before we get into it in some more detail, I thought I'll just give the case reference on this. We're talking about I'm going to try and pronounce this. We should have one of our Russian colleagues on to do this bit of it. But anyway, we've got the Yegia Zayan and Smadjan case. This has gone all the way to the Supreme Court of the United States. So we're dealing with a decision from the highest court in the US, which is always exciting. And the case citation is 143S.CT.1900, handed down really recently. This decision came out in June, on the 22nd of June, 2023. So yeah, it's a good one to get into. Now, where should we start? I have a feeling it might be worth just talking about Rico in some broader terms first. Ed, what do you think? And then we can kind of get into this case and where it sits within the overall, summary.
Yeah, I think that's a great idea on how to start and to provide some context regarding the Rico Act. And likewise, as we have that discussion, touching a bit on a related Supreme Court decision from 2016, which really threw a wrench in expectations about RICO that had previously existed in the minds of many U.S. attorneys. So to get started, I'm happy to chat a bit about the Racketeer Influenced and Corrupt Organizations Act in general.
Well, let's do it. Let's get into it.
So as I mentioned earlier, RICO was implemented to address the kind of stereotypical scenario in which a criminal organization injects itself into an otherwise proper and legal business, in particular, a business enterprise. And I use the word enterprise because that is one of the key elements, if you will, of a RICO action. The statute itself is contained at 18 U.S. Code 1962 and the sections that follow. And it begins by providing, as many statutes do, a series of definitions. And one of those definitions, there's any number that we could really touch on, but one of those definitions that's important to keep in mind is a pattern of racketeering activity. The statute looks to prohibit certain types of conduct which are premised upon or utilize a pattern of racketeering activity in order to gain material wealth. The statute defines a pattern of racketeering activity as two or more incidents of a racketeering activity within a 10-year span. Case law has not surprisingly put a gloss on that, which is that the independent actions of racketeering activity, those separate incidents, need to have a degree of relatedness and continuity. They have to be connected.
And just pausing there, Ed, when you refer to racketeering and conduct like that, I think, at least when I first came into RICO many years ago now, but I had a kind of narrow view of what that type of conduct may relate to, thinking about, quite serious criminal conduct. And of course, any crime is serious, but thinking about, the money laundering and the other types of activities that you would associate with organized crime. But it's not really limited in that way, is it? There's all sorts of, wire fraud and, different types of conduct that can fall within that kind of racketeering definition there and form the pattern of conduct that you need for this type of action.
Yeah, exactly, Luke. And racketeering activity is another one of the defined terms. It's one of the longest running definitions I've ever looked at in a statute. But in essence, what it says is that racketeering activity means, and then it lists out a number of different categories under state law, so meaning New York state law or California domestic state law in the U.S. And those include murder, kidnapping, bribery, extortion, which are felonies under any state's law. And then it goes on to list a series, probably 2 or 3 dozen, distinct criminal statutes in the U.S. as to which violations also constitute racketeering activity. And those include a variety of types of bribery, corruption of justice, tampering with witnesses, and so forth. But importantly, especially for those of us dealing often in the business context, the scope of racketeering activity under federal law also includes wire fraud and mail fraud. And those two types of fraud, which are statutory frauds in the United States, essentially mean the use of interstate or international wires or mail postal systems in order to execute or advance a so-called scheme or artifice to defraud. And a scheme or artifice to defraud can be broader than the typical common law understanding of what fraud means. It's not just limited to material misrepresentation of a material fact reasonably relied upon causing harm. It's broader. It's really any scheme to deprive another person of their rightful property. And so it's a broader definition, and that's where the wire fraud and mail fraud categories of racketeering activity can become quite relevant in the business context.
Seeking to defraud creditors, moving money around, creating shell companies, making illegitimate transfers away from awards, witness tampering, all those kinds of things can fall into the list of conduct that you need to bring a RICO action. And indeed, those are the types of actions that we're dealing with here in the underlying case. But then one of the other aspects to this, Ed, and where there's been quite a bit of controversy is around where the injury is suffered by this type of conduct, and the concept of a domestic injury and what that means.
Yeah, exactly. And that brings us to the case that I mentioned from 2016. That was another United States Supreme Court decision. That case was RJR Nabisco versus the European Community. And without getting into the details of that, the takeaway holding by the U.S. Supreme Court was that for a foreign plaintiff to bring a racketeering action, a RICO claim in the U.S., that plaintiff had to have suffered a so-called domestic injury. However, in the RJR Nabisco decision from 2016, the Supreme Court did not have the occasion to actually delve into the meaning of domestic injury. So this phrase, domestic injury, was put out there, but it was then left to district courts and circuit appellate courts to consider and come up with different formulations for analyzing what a domestic injury is in order to give standing to a plaintiff to bring a RICO claim.
It's a slightly tricky structure, the U.S. court structure, because you have a decision like the one in RJR Nabisco. If I understand correctly, the court said a foreign party can have a RICO claim. They're not barred from having a RICO claim just by being foreign or by being foreign domiciled, but they have to have some kind of domestic injury. Unlike in the English system, where it's very linear, and that decision then goes down to the junior courts, you then have a system where all the different circuits in the US have to try and decide what is meant by domestic injury. Naturally come to slightly different conclusions on a phrase like that, which is probably rather easier to see a domestic injury than it is to define one. You end up in a situation where all these different circuits can come to different conclusions on what a domestic injury is. It then sort of bubbles back up to the Supreme Court. But I presume for the Supreme Court to take on one of these cases, they have to see it as an issue which is arising under different multiple different circuits.
Yeah, exactly. And that's why the case ended up before the U.S. Supreme Court. One of the bases for the United States Supreme Court to grant certiorari is that there has developed a circuit court split, meaning that two or more of the different circuit appellate courts in the U.S. have taken a divergent view on a significant issue. And thereby, it's one that the Supreme Court should resolve so that there is a uniform application across the U.S. And in this situation, there most certainly was a divergence, a split between the circuits. The Seventh Circuit, the Seventh Circuit had gone one route and taken a very strict line and looked at the domestic injury requirement as being one that solely considered the situs of where the plaintiff would have felt an injury to its intangible property. On the other hand, the Second Circuit, as well as the Third Circuit Courts of Appeals, had taken a more nuanced approach, a broader spectrum, and they looked contextually to see whether the injury arose in the United States as opposed to whether it was felt in the United States. So the divergence between the circuits could be described best, I think this is fair based on what the Supreme Court has said, as to whether a court should be looking at where the injury was felt, in which case traditional common law views regarding the situs of an injury would come into play, or whether it should be assessed based upon where that injury arose, in which case one might consider a broader context of factors. What conduct was undertaken?
Yeah, exactly. And it's kind of been described that latter approach as a context-specific approach. So rather than the narrow approach, as you say, which is based on residency of where the plaintiff is and where the domestic injuries technically fell, you're looking at more of a context-specific approach on this other kind of scenario where you're looking at all the facts. You're looking at what has happened here, where the conduct had occurred, and then how that conduct played out. What was the cause of that conduct, and what was then suffered by that conduct, and where. And it's a much more. I think it gives the courts much more latitude to look at different situations. And perhaps we should just explain some of the facts of this case as well to kind of dig into it a little bit. But what this context-specific approach does is it allows the courts to consider the wider picture rather than a very narrow, almost like a common law negligence type approach where you're just looking at where the injury is felt.
Absolutely. And so happy to give the background facts on this case if that's where we should go next. Yeah. So in this case, in this situation, Mr. Smagin, and like you, Luke, I'm going to butcher pronunciations here with sincere apologies to anyone who can better pronounce these names. But Mr. Smagin held an $84 million arbitral award against a Mr. Yeji Azarian. As alleged in the action, Mr. Yeji Azarian, who had been living in Russia and had entered into some real estate joint ventures with Mr. Smagin, had fled from Russia and moved to California. Apparently moved to something of a very nice mansion in California.
Up in Beverly Hills. Yeah.
Beverly Hills or someplace like that. Sounds good to me. It's a beautiful spot. And proceeded allegedly to take steps to insulate himself and his assets from future judgment enforcement, award of enforcement and judgment enforcement thereafter. And the scope of allegations included setting up shell corporations in the United States, which would have been nominally owned by relatives or other close associates, and likewise arranging for business associates to bring supposedly fraudulent claims against him around the world, so that assets in other countries could be frozen and thereby insulated from recovery efforts by Mr. Smagin. And during the course of all of this, after Mr. Smagin had obtained his award against Yeji Azarian obtained an award for about $198 million against a completely unrelated third party by the name of Karamoth. In about 2016, Smagin became aware of the award which Yeji Azarian had against Karamoth, $198 million, obviously enough to satisfy the $84 million award that Smagin had against Yeji Azarian, but also apparently became aware of the shell companies that had been set up in the United States, as well as aware of the various insulation actions which had been brought against Yeji Azarian in other courts around the world. And based upon that information, he proceeded with a Rico claim, which in essence contended that Yeji Azarian was using mail and wire frauds to orchestrate a fraudulent scheme to insulate his own assets. And there was one other consideration that plays into those allegations, which was an assertion that Yegizarian had forged a doctor's note which supported Yegizarian in not showing up for a hearing before the recognition court in California, and that Yegizarian, beyond that, put some influence on the doctor whose name was purportedly tied to that doctor's note in order to sway that doctor's potential testimony. So pretty complex series of facts there, but I think it boils down to a situation where Smagin had a very large $84 million award against Yegizarian. Smagin learned that Yegizarian had assets coming into him to the tune of $198 million through another award which had been settled, and allegations that Yegizarian then proceeded to insulate both the proceeds from that award settlement as well as other assets from potential enforcement efforts.
Yeah, and look, I think that's right, Ed. And the upshot is that there were a number of steps, wrongful steps that were taken in the United States. There was a lot of conduct that happened in the United States. Not all of it, certainly. But Yegizarian took domestic U.S. actions to avoid collection. He set up U.S. shell companies to hide his U.S. assets. He submitted the forged doctor's note, as you say, to the California District Court and intimidated a US-based witness. And all of these steps, as well as other components of the scheme which occurred abroad, they had the central purpose of frustrating the enforcement of a Californian judgment with Yegizarian sitting in California. And my view of this overall case, and I think what ultimately guided the courts here, as well as the ruling on the legal principle about this, whether it's a residency-based approach or whether it's context-specific, is it really does get past the sniff test when you think about it. You have a Californian judgment, someone sitting in California implementing a number of US-based frauds or, wrongful conduct, let's just call it, as well as conduct happening outside. This does seem like the type of scheme and the kind of, racketeering, I mean that in a broad sense, that the US Congress would wish to prohibit and would expect the courts to kind of come in hard on this kind of conduct. Now, I know that's not the legal test, but I do think sometimes in these racketeering actions, when you're looking at the domestic injury issue and some of these other factors, you have this overriding question of extraterritoriality. And if most of what's happening is outside of the US and it's kind of tangential what has happened within the US, and I think it's tricky, right? If, however, there's, part of the central purpose of a scheme falls well within the US, then you're going to make good headway. And that's kind of an overall comment. And of course, we should get into the specific legal principles. But I think that does add some color to how the court ruled here.
Yeah, and this is what I was thinking as well, Luke, when I was reading the case. It seemed like a pretty US-based fraud, or the Rico activity is US-based. And I suppose that's where you get into this confusion over domestic injury, because it's not a domestic fraud, it's a domestic injury. And it's almost harder to pin down where an injury occurs rather than where the wrongdoing occurs. I think you would certainly here have domestic wrongdoing, or at least domestic to the US wrongdoing. The more tricky question is, and this is almost something which is the legacy issue from the RJR Nabisco, as I understand it, is that you have to say, not only is there some kind of wrongdoing, and likely domestic wrongdoing, I don't think it needs to be though, but there's also this domestic injury. There's just this sense that you're harmed in the US in some way. And I think here, as you say, like it goes straight through the sniff test, because a lot of the wrongdoing was really around the California enforcement action. And if Party A is trying to enforce against Party B in California, because that's where Party B lives, and Party B does take some fraudulent steps, or take some steps that fall within this RICO legislation, to avoid that enforcement action, it's hard to see how the injury didn't happen where the enforcement action couldn't be performed due to those wrongful steps.
Yeah, those are all great points. And a comment which is made in the Supreme Court's decision here regarding extraterritoriality, and we should talk more about the presumptions about extraterritoriality and so forth, but a comment that's made focused on the actual language of the statute of RICO, where it empowers a private plaintiff to bring a RICO action and actually recover treble damages plus attorney's fees. And the provision of the statute there says, I'm paraphrasing, but the language is that any person injured in his or her business or property by reason of a pattern of racketeering activity can bring a RICO claim. And the Supreme Court focused on that language, by reason of, and that's tying together both the injury and the circumstances that gave rise to that injury. And based upon that connection, that tie together, the Supreme Court says, well, if you have a situation where somebody has been injured and they've been injured by reason of certain conduct, you have to take a contextual look at the whole picture to figure out where that injury actually arose. And it's that phrase, by reason of, that really ties it together and broadens the scope. And as you both said, this was something of the perfect case in which to address domestic injury, because there certainly were strong allegations of wrongful, illegal type conduct in the United States that tied together with the injury, even if the injury itself might have been felt overseas.
Yeah, and you can also see why it makes sense to read the statute in that way, because if it was purely based on a residency test as to whether you can avail yourself of a RICO claim, then there are principles of comity that would come into it. You know, why are U.S. citizens only able to benefit from this statute and not foreign citizens? If that was going to be the case, then you would expect it to be dealt with in clearer language, and that there is just a very simple, or straightforward threshold to get into RICO, and that is that you need to be resident in the US. But this concept of domestic injury, and also I think when you think about, as you opened up, Ed, that to succeed in a RICO claim, you have to have a pattern of wrongdoing. So a pattern of wrongdoing, well, it needs to be somewhat related or connected or have some kind of, has to be tied together in some way. It does suggest conduct happening over a period of time and in multiple ways and in different types of ways. And that, I think, that combined with a domestic injury suggests a broader type of analysis than a simple, straightforward one incident. Where did it happen? Who suffered it? And what was the injury from that one incident? It does, I don't know if I'm explaining myself very well, but almost by the nature of the pattern of wrongdoing that you require to fall within RICO, you're in a broader analytical or a kind of a context-specific scenario already. So why you would then bring something very narrow in as a threshold to get into it, it just doesn't sit well for me. And so I think when you look at the bigger picture here, and through that prism, this decision makes a lot of sense.
Yeah, that's a great point, Luke. And running throughout RICO and through courts' analyses of RICO, there are numerous instances of a broad-reaching analytical approach, a broad paradigm for analyzing these cases. Just as one example, you mentioned the pattern of racketeering activity. And that's a whole separate topic right there from the domestic injury topic, but it's one that there is a vast body of case law dealing with. What constitutes a pattern is not a simple question, and the courts here have developed two primary lenses through which to view a pattern. One is looking for so-called open-ended continuity, and they look to see, has there been a series of racketeering type activities with a continuing threat for further instances of racketeering activity to occur ongoing into the future. That's one approach. Another approach is so-called close-ended continuity, where things happened in the past, but for some reason, a hard marker has been put down, and that particular pattern is not going to continue into the future. So that right there is a very open-ended, broad-reaching approach to analyzing these, and also just the statute itself, where it defines the range of racketeering activities. It covers everything from murder for hire to kidnapping to bank fraud to wire fraud, as well as illegal gambling. So you're talking about a statute that really has vast reach. And it's appropriate, in my mind, to have an injury analysis that is equally open-minded.
Nearing the end of the discussion, I think, chaps, but I think the takeaway here is that the court ultimately ruled that you do apply a context-specific approach to this analysis rather than simply a residency-based approach, which you may find in some of the other common law causes of action. And so, I think that's that has really helped clarify things. It's also arguably broadened the scope of domestic injury in a sense than where it may have been, so that there is a little bit of a pendulum swinging back towards opening up RICO a bit more, I think, as a result of this decision. Calum, did you have any other thoughts on this matter?
The other thought I wanted to get into a little bit with Ed was the dissent. Something you said earlier, Ed, just gave me a bit of pause there as well. And this is coming from a perspective of somebody who's not that familiar with the US lexicon, if you like, around judgments. But the dissenting decision from Justice Alito said, rather than take this unhelpful step, this is referring to essentially giving the judgment, Justice Alito said, I would dismiss the writ of certiorari as improvidently granted. A nice sentence, but what exactly does that mean, Ed? What's a writ of certiorari?
Yeah, I understand Justice Alito, and he was joined by Justice Thomas, and I think in part by Justice Gorsuch. I understood his point there as being that the Supreme Court should never have granted certiorari in the first place for this decision, and that it should have changed its mind on that issue and not considered the case. Keep in mind that not every single case has a right to go up to the U.S. Supreme Court, while a dissatisfied party will generally, subject to time limits and all of that, and ripeness, but while a dissatisfied party will generally have the right to seek appellate review at the circuit court level, meaning the intermediate level court, there is absolutely no right to inherent review by the U.S. Supreme Court. And so Justice Alito here was basically saying, we shouldn't be considering this. Now, as to why...
Effectively he's saying leave to appeal should not have been granted in English law terms.
No. Yeah. And I think he's saying that because reading through the dissent, he seems to have to take that the underlying issue, how to define, how to construe a domestic injury, had not been batted about enough by the circuit courts and the district courts, and that there wasn't enough solidity kind of in what those differing views were. And he's also dissatisfied by the scope of guidance being given by the Supreme Court to the lower courts, because reading the dissent, it seems to be viewed that this is a wide-reaching decision without any firm rules, nothing close to a bright-line test, and so that it could open the door to problems and confusion at the lower court levels. Of course, a contrary view to that is let them think it on through at the lower court levels.
The dissent was an interesting one from an English law perspective, because I'm used to seeing dissenting decisions, used to seeing dissenting judges, but normally they put forward what they say the answer should have been. Whereas this one effectively just says, no, the decision shouldn't, we shouldn't be talking about this. As a secondary point, the way that we have talked about this have been wrong and unhelpful. Which is quite an interesting. These little changes between the English approach and the US approach interest me quite a lot when we're reading these cases and doing this exercise of case by case. And that was an interesting one that I picked up. But I think my take on that was there might be a point there, which is in this US court system where things go out to the different circuits. If the guidance from the Supreme Court is not as clear as possible, then you do run the risk of you create more confusion, or you create another wave. Are we sufficiently advanced from the uncertainty around domestic injury by saying domestic injury is a fact-based question, or a fact-based issue on which we have to take into account all the different issues, all the different factual inputs to come to a decision? I'm not sure that does advance the legal understanding for the lower courts hugely, and I have some sympathy with the dissent on that basis.
Yeah, I see what you're saying. I think also though there's been a narrowing of domestic injury, right? And the view on Rico has been that the window into it has been narrowing. And my read, and this is purely opinion, of course, is that the majority took the opportunity to say, well, no, there are opportunities where foreign plaintiffs should be able to access the US system when it's clear that part of the injury is occurring within the US, without putting, too narrow a line on where that divide is. And my read of the majority decision was that the courts should feel like they have the freedom to pull certain cases within Rico that deserve to be pulled within Rico. Now, I think the dissenting judgment here, they also suggested that there's a reluctance, or there's a concern, and there always has been, of US courts giving foreign plaintiffs more remedies within the US than they may have within their own home jurisdictions. And I think that was an element to this. And I can see that there is an international comedy aspect to that, where I can see that there might be reluctance from a very senior US court perspective, the most senior, in opening the floodgates to foreign plaintiffs looking to the US as, well, this is the place you go if there's some kind of wrongdoing, and if it touches the US in some way, then go after RICO claim. And when they may never have that type of claim in their home jurisdiction. And so I think that was an element of it. But it's an interesting observation, Calum, where, coming from an English perspective, you would expect to see the dissenting judgment saying, well, I don't think this should have been before us, and have some comments in there about this and say it shouldn't have got permission, et cetera, et cetera. And we think it should be the residency approach for X, Y, Z reasons. And that's then fleshed out in the dissenting judgment, rather than, as you say, more almost commentary on whether it should or should not have been before the court.
My take on this too, just kind of forward-looking expectation, is that in due course, as district courts and also the circuit courts of appeal address domestic injury cases going forward, it wouldn't surprise me at all if they landed on some type of a balancing test based upon the Smagin decision here. And U.S. courts, I think also the English court system as well, are quite familiar with balancing tests. They're used routinely in connection with choice of law analyses, in connection with forum nonconvenience analyses, and where you look at what's the total mix. Obviously, the exact paradigms for those different tests vary, but you're looking at the end of the day, what's the total mix of international interests and international contacts in a forum non-analysis or in a choice of law analysis. You're trying to see which way it tips. Is it in country A or is it in country B? But in connection with domestic injury, the question would be, are there enough to view this injury as having arisen in the U.S.? Are there enough contacts with the U.S. to view it as having arisen here? And in the Smagin decision, those contacts were a defendant who was reportedly, allegedly orchestrating the scheme from California, a Californian judgment on an award that was being circumvented in terms of enforcement opportunities, assets that were being moved around in the United States, and then broader coordination along with the allegations about witness tampering, all in the United States. And so you had a wealth of contacts to the U.S. that kind of tips that balance into the U.S. And I suspect that in the future, the lower courts are going to kind of develop that type of an analysis to consider these situations.
I entirely agree, Ed. It is a fascinating dissenting judgment there, and I don't think we should focus too much on it. But this paragraph is a beauty. The only rule of law that the court announces today is that there is no rule. And despite offering such minimal guidance regarding how to cite a RICO injury, the court nonetheless manages to sow confusion regarding our broader law of extraterritoriality. Respectfully, the most we could contribute to this issue at this juncture is to stay away from it. I would dismiss the writ. That is such a wow. It's a big statement, isn't it? You kind of that's the words of the dissenting justices here, not my words. But and I will preface what I say with respect. But it's, I don't know, you tend to think that the highest court in the land, if they've had to turn their mind to an issue, would come at it and say either this doesn't require clarification because it's clear on the plain words of the statute, or we think that this is the right way to be dealing with it, or not the right way to be dealing with it. But the concept that the highest court should stay away from it and leave it to the lower courts, I really think it, as you said earlier, is a reflection of the nature of the court system in the US. It's that I struggle to see that type of statement being made in say an English Supreme Court decision. But anyway, look, it's a fascinating one. I've really enjoyed this discussion. And any final words on it, guys?
Not from my side. Thank you for the discussion.
No.
Always instructive. Learned a lot from you both on this, on US law procedure and RICO. I'm going to be sniffing out RICO action now in every case I see, trying to find a way to hook it into US jurisdiction. That's the problem.
Keep that in mind, Calum. It's a great statute out there if you use it properly and you do your homework on it. It really active. So thank you both for having me on Case by Case. I was pleased to be back on and look forward to the next time.
Okay. Well, thank you everyone for listening in. Ed, thanks for joining us. It's been great having you on. And on a topic you know so well. We've enjoyed our RICO cases over the years, and this is going to make things interesting. I think there's going to be some interesting debates, discussions, ideas coming out of this. So I hope you've all enjoyed the discussion. If you want to hear more about RICO, or get in touch, feel free. Happy to chat it over. If you disagree with us, you think we're not seeing it the right way, by all means, give us a bell. But thanks for listening in, and until next time, take care, everyone.